Good morning all. I'm really honoured to make a contribution at this conference of the Society in a session marking the professional contribution of my friend and mentor, former High Court Justice Ian Callinan. Can I say how much I respect and appreciate the way that the Samuel Griffith Society lives out its belief in the value of the Federation by genuinely treating each state as equals, regardless of their population or remoteness, and living out that belief, including by travelling the length and breadth of the country. I think it makes us more robustly articulate the issues that face the nation because we are deeply interested in every single state and territory and its people. Can I extend my acknowledgement to the judges in the room, my parliamentary colleagues from all around the country, but members and friends, it is a joy to be here. But before I go into my analysis of what I think is the most important of Justice Callinan's judicial contributions in the work choices case, can I mention the passing of John Stone, without whom this society would never have become what it is today. May God rest his decent and collegiate, if delightfully argumentative, soul. Now, in the legal profession, we love a good doctrine, the comfortable bounds of precedent, the safety of a principle, though we like to keep just enough uncertainty to keep the briefs for advice and the interesting litigation coming through the door. Now, I must confess there is not at the present time any formal doctrine of precedential patience, but the principle I'd like to advance today is this: that there has been, with the passage of time, something of a vindication of the wisdom of the judgments of Ian Callinan. That's true across a range of fields of legal inquiry, but as I mentioned, I intend to focus on what I think is the most important of them. It's now been 18 years since His Honour retired from the High Court of Australia. The passage of time and of events gives us the benefit of a hindsight that cannot help but teach us of the value of concepts like judicial restraint, fidelity to the federalist approach that His Honour so regularly articulated. I would suggest that there was no case in which that foresight was more clearly on display than in His Honour's dissent in the work choices case. It's my contention that if the lessons offered by that opinion for both the legal and the political class are learned from that contribution, heeded deeply, then we might just be able to solve some of the most pressing problems that face the nation into the future. Now, the work choices case is well known to many of you, but given it is now almost 2 decades old, and very pleasingly, a large number of the people in this room were not likely born at the time that it was handed down, feeling a little old right now, I'll briefly summarise the issues with which it contends. I'm really glad it was touched on last night in Richard Court's address. The Howard government, encouraged by the strength of its support at the 2004 election, determined to use its rare Senate majority to legislate for greater industrial relations reform than had yet been achieved. It's worth observing that much progress had already been made by that government in the policy area of industrial relations, with dividends that were already being felt for productivity and higher living standards. But eager to do ever more, the Workplace Relations Amendment, Work Choices Act of 2005, was passed. It differed to the previous approaches in that it sought to rely on several heads of Commonwealth power, but in particular the corporation's power, as the basis for the validity of the legislation. It also sought to apply to bodies incorporated in the territories, using the territories' power, to Commonwealth authorities and anyone who fitted in with a number of the other smaller categories in relation to constitutional trade and commerce, like flight crew workers and marine employees. And the explanatory memorandum to the Act observed that as it was framed, the industrial relations regime it established would cover 85% of the employees in Australia because the bulk of employers would fall within that definition. It offered, for the first time, a truly uniform and national industrial relations system. Importantly, the Act sought to apply to the exclusion of state and territory laws that would have otherwise applied in relation to industrial matters, covering everything in relation to an employer and an employee, and a broad field of topics that together we would now call those states and territories laws of industrial relations. So it sought to cover the field and override the pre-existing state and territory regimes pursuant to section 109 of the Constitution. The impact it had on the states was broadly uniform, but it's worth mentioning Victoria, which had voluntarily referred a range of matters in relation to industrial relations to the Commonwealth back in 1996. Nevertheless, Victoria opposed it because it claimed that the Federal Act nevertheless went beyond the matters the subject of that referral. 2005 wasn't the first time the Commonwealth had sought to legislate in the sphere of industrial relations. Of course, that doesn't necessarily mean that use was valid in the absence of a specific ruling on the matter, and any decision to invalidate the work choices legislation for its inappropriate use of the corporation's power would have implications for those earlier acts. Justice Kirby observed that there had been public debate, if not judicial determination, of whether this was a valid use of the corporation's power, since the previous government had legislated for enterprise flexibility agreements back in 1993. And while there were a number of questions of law for the court to decide, there really was one big issue with which to grapple: the scope of section 5120 of the Constitution, the corporation's power. The Commonwealth had taken a very broad view of what fell within its scope, seeking to offer a broad-based and national industrial relations regulatory system. But if the Commonwealth were to succeed, the implications for the centralisation of legislative power in the Federation would be profound. On reflection, perhaps only the minority realised quite how significant that impact would be. The majority considered the pre-Federation cases, then briefly the constitutional debates, before observing that the convention debates, in their view, revealed very little about what those who framed the Constitution thought would fall within or outside the power. Their honours said, to pursue the identification of what is said to be the framer's intention, much more often than not, is to pursue a mirage. It's a mirage because the inquiry assumes that it is both possible and useful to attempt to work out a single collective view about what is now a disputed question of power, but then was not present to the minds of those who contributed to the debates. Now, I don't cavil with the notion that the precise arguments run by the plaintiffs about internal and external relations within a corporation weren't discussed at the constitutional conventions. Plainly, they weren't documented. But a great deal was said about what we now call industrial relations and who was to be responsible for it. In the submissions that Queensland made, and broadly, with some nuance, those were followed by the other states, the corporation's power in its submission should be narrowly understood. Queensland's submission observed that the Australian people had at a referendum rejected proposals to broaden the scope of the corporation's power and had said that the rejection of those proposals, for there had by that time been 3 of them, by the sovereign Australian people should be a powerful aid in construction. Despite that, the majority held that it was a flaw of reasoning to draw any conclusion about the meaning of the corporation's power by the rejection of a referendum to expand its scope, even if it had happened 3 times. Their honours held, it is altogether too simple to treat each of those rejections as the informed choice of electors between clearly identified constitutional alternatives. And while broadly the majority's view that a referendum can fail for a number of reasons, such as party politics or poor framing of the question, that is right, it's in my view, a mistake to treat the voter as uninformed and without a nose for the powers that they do and do not want certain governments to have. They may not be offering a word-by-word definition of the present constitutional provision in the way that a lawyer might, but when a request to expand a particular Commonwealth power is thrice rejected, the people are plainly sending a message about what they do not want. In any event, the majority construed the constitutional text with all the generality with which the words admit. It then determined the character of the law by reference to the rights, powers, liabilities, duties and privileges which it creates, examining what it said were the practical as well as the legal operation of the law. Queensland had argued that it was necessary to limit the reach of the corporation's power to a scope that was narrower than its ordinary words would suggest, because to do so broadly would adversely alter the federal balance, the notion that it would give rise to extraordinary and negative consequences if the Parliament had the power to make any kind of law on any subject affecting such corporations. In doing so, Queensland drew on the decision of Justice Gibbs in Fontana Films, but this was rejected by the majority as being little more than a vague assertion because the content of that balance, that federal balance, had not been precisely defined by Queensland. And so, perhaps unsurprisingly then, the majority held for the Commonwealth on all of the arguments. Justice Kirby, like Justice Callinan, dissented from the decision of the majority, and while I may mention Justice Kirby's remarks in passing, I'd now like to turn to what I suggest is the better of the approaches taken, that is the dissent of Justice Callinan, and to say something of the ways in which I would suggest its wisdom better serves the Constitution, the nation, and Australia's people. His Honour's judgment carefully outlines the history of the law in the field of industrial relations, alongside the history of Australia's Constitution, as set out in the Convention debates, and by tracking the referenda and precedent thereafter. His Honour, and to be fair, Justice Kirby, identified the significance that the decision would have with great precision and clarity, I would suggest more so than the majority did. Justice Callinan said, paragraph 619, this is one of the most important cases with respect to the relationship between the Commonwealth and the states to come before the court in all of the years of its existence. If the legislation is to be upheld, the consequences for the future integrity of the Federation as a federation and the existence and powers of the states will be far-reaching. The Act in its present form is well beyond and in contradiction of what was intended and expressed in the Constitution by the founders. So, perhaps unsurprisingly, no spoilers here, His Honour held the Act invalid and found against the Commonwealth. So I'll touch on, I think, what I believe are some of the gems of principle that emerge from His Honour's decision. The first was in relation to how we should treat the objects of legislation. His Honour held, to put it simply, that the objects of an act really do matter, that they tell us something important about what legislation truly does intend to do and whether or not its use really does align with the claimed heads of power. The objects of the Act in question showed that the Act sought to offer a national industrial relations system, quote, without any attempt to connect, even by the narrowest of threads, those objects with some implementation of the corporation's power. The common sense of looking at an act for what it is, what it plainly seeks to do, is, in my view, refreshing rather than the legalistic approach of others. Ultimately, if it walks like a duck and it quacks like a duck, it probably is a duck. His Honour offered great wisdom too in the way that we should consider and use the convention debates in decision-making. The majority had, as I've mentioned, boldly held that the convention debates had little to offer in determining the case. Far from the assessment of the majority, Justice Callinan observed that there is much to be gained by considering the debates as they related to the corporation's power, particularly when they were considered alongside Section 5135. He observed that enough appears from debate on those two related but distinct subsections, quote, to demonstrate that the founders never intended the Constitution to confer any intrastate industrial power upon the Commonwealth, despite that some of the delegates might have wished it otherwise, close quote. His Honour further observed, what is also apparent is that none of the lawyers, politicians and judges to whom I have referred, and he was referring to the convention debates there, even remotely contemplated intervention by the Commonwealth into industrial affairs, other than by enactments under Section 5135. The whole tenor of the Convention debates about industrial affairs was that they could be divided into two categories only: intrastate and interstate. No one suggested that the debate, so far as corporations were concerned, was an arid one, because the industrial affairs of these were already within the Commonwealth's grasp under the corporation's power. His Honour's view that the contemporaneous account of what the framers of the Constitution were thinking is highly relevant. It's a view that I think would continue to serve us well, particularly if we share the Founding Fathers' belief that the Federation does not function overly well if it is overly centralised with hollowed out states. His Honour's comments in relation to the relevance of referenda were also important. Observing the fact that there had been 3 attempts to change the Constitution by referendum to expand the scope of the corporation's power shows, at least from 1910, that it was, quote, understood by the Parliament that it could only exercise general, effectively almost exclusive legislative powers, and with respect to corporations as well, for industrial affairs, if the Constitution were amended. It's reflective of a broad understanding. I'd suggest that the respect for history that His Honour demonstrated stands in some contrast to the majority. His Honour went on in paragraph 732 to say, what happened in the referenda to which I have referred is particularly compelling because of the repetitiveness and ingenuity of the attempts made by the Commonwealth to gain the power, which in this case it now says it always had. The court should not disregard that history. The people have too often rejected an extension of power to do what the Act seeks to do for that. To ignore the history would be not only to treat section 128 of the Constitution as irrelevant, but also for the court to subvert democratic federalism for which the structure and text of the Constitution provide. At a time when the majority were not prepared to read really anything into the Australian people's decision to reject the proposals for a wide corporation's power, His Honour, recognising the intelligence and common sense of voters, held at paragraph 733, I am not prepared to regard the people as uninformed. An approach to constitutional interpretation that recognises the primacy of the Australian people in its design is one which best guards the institution of the Federation against revision by an elite class of, albeit learned, judges. His Honour had much to say about the importance of understanding the Constitution as, at its essence, a federalist document. His Honour considered the approach to be taken in construing the Constitution, particularly in light of the approach of textualism that had been adopted by the majority in the engineers' case. There, the majority expressly rejected the notion that one should have regard to the policy objectives of the Constitution and construe it as one would a statute. But just as Callinan observed, pushing back at what seemed to be something almost universally accepted in the submissions, that, quote, at paragraph 741, to disregard entirely, or perhaps the fundamental policy of the Constitution, federalism, and the careful division of power that it involves, is to disregard, or is at least to attach little weight to, the object which, beyond all doubt, the framers intended, the people who voted in favour of federation adopted, and the Imperial Parliament implemented. And of course, it runs contrary to the proper method of statutory construction. His Honour observed that the engineers' case, which had been treated at that time by others as wholly settled, was itself a split judgment, and a case which, quote, does not deserve the reverence which has been accorded to it. In short, His Honour explained that it is a mistake to try and interpret the Constitution as though the project of federation were some merely historical perspective on its drafting. Federation was its entire purpose, the thread that weaves every word and every provision of it together. It cannot be understood, at drafting or today, without reference to the object of binding together every state in a cohesive nation with clear powers. Any interpretation that would massively centralise power at the expense of the federal balance undermines the entire project, such that it cannot be the appropriate one. Many of you know that I now serve in the State Parliament of Queensland, with responsibilities in the field of finance, among others. One need only glance at the hangover of the centralisation of income taxation in the Commonwealth for hamstringing the state's ability to both fund and deliver what they must to see what the dangers of centralisation are. Vertical fiscal imbalance is not a product of work choices, but this decision affected an analogous transfer of similarly large powers to the Commonwealth. And given the link of corporations to, let's face it, every area of public and commercial life, hospitals, education, transport, I could keep going, the peril of that centralisation is real. There are implications for service delivery, for responsible budget management, and trust in the institutions themselves when the state's ability to both fund and deliver have been eked across to the Commonwealth. His Honour offered warnings against the urge to update the meaning of our Constitution. His Honour seized the opportunity in work choices to affirm the decision that he and Justice McHugh had delivered in the matter of Singh in the Commonwealth, to warn against the temptation of courts to update language to reflect changing times, as part of his urging of the continued use of reference to convention debates to understand meaning. That wisdom is, at paragraph 736, quote, "There are compelling reasons why recourse to the debates is permissible and will usually be helpful. Courts and judges may speak of the changing meaning of language, but in practice, substantive linguistic change occurs very slowly, particularly in legal phraseology. When change does occur, it generally tends to relate to popular culture rather than to the expression of fundamental ideas, philosophies, principles, and legal concepts. Judges should, in my opinion, be especially vigilant to recognise and eschew what is in substance a constitutional change under a false rubric of perceived change in the meaning of a word or an expression used in the Constitution. That power to effect a constitutional change resides exclusively in the Australian people pursuant to section 128 of the Constitution and is not to be usurped by either the courts or Parliament. In any event, I am not by any means persuaded that an actual change in the meaning of a word or a phrase, if and when it occurs, can justify a departure from its meaning at the time of federation. The constitutional conservatism of the Australian people, reflected in the failure of so many referenda, cannot justify a supposed antidote of judicial progressivism. His Honour calls out those judicial activists who would seek to dress up lawmaking, properly reserved for the democratically elected, up as merely staying relevant. There's a very good reason why Australians have, even very recently, been unwilling to embrace revolutionary change when it comes to their constitution, and it's important that our courts respect that. His Honour urged us to guard against excessive generality in the way that we approach interpretation. In tackling the majority's approach of simply interpreting the words of the Constitution conferring powers with all of the generality with which the words used admit, that well-used expression, Justice Callinan was scathing in his assessment. In my words, not his, he's far more eloquent, the judge described this as something of a cop-out. He observed that in the decision of Justice O'Connor in Jumbunna Coal Mine, almost certainly the source of the expression, His Honour was still careful to make clear that generality in interpretation must make way to context and other limiting provisions in the Constitution, a matter about which sight appeared to have been lost. Justice Callinan wisely held, the generality doctrine may be carried only so far. It cannot be used in such a way as to defeat two of the most elementary principles of all instruments and legislation. Elementary principles of construction of all instruments and legislation, that effect must be given to the intention, the objects and purposes of the document, and that it must be read and construed as a whole. So yes, generality in interpretation applies, but not in a vacuum from the other provisions of the Constitution that are plainly there to limit its operation, lest those other provisions have no work to do. That's wisdom that I suggest has aged well. His Honour had a little more to say about the inappropriateness of judicial activism when considering the powers of the court as part of interpreting the Constitution as a whole. He observed that the court's power to interpret the Constitution must not be read as a right to alter it, and yet that is what upholding the Act would require the court to do in relation to the scope of the corporation's power. And finally, His Honour urged us to resist the urge to centralise. His opinion hit back hard at the majority's trivialisation of the concept of there being a federal balance that underpins the Constitution's drafting as a whole. His Honour held, quote, "Sight should never be lost of the verity that the Constitution is a constitution for a federation and that it provides for a federal balance. It may be in any event subject to constitutional implications, and the maintenance of the federal balance is a powerful one of these. More powerful than, for example, the implication of freedom of political speech, not a word concerning which, unlike the repeated references to the states, appears in the Constitution. The Court has at various times been willing to find in the Constitution things that are not expressly drafted, such as an implied freedom of political communication. To do that, whilst denying the ongoing interpretive significance of the federal balance on which it was framed, is not just a nonsense, it undermines our political and democratic institutions." His Honour put it simply, quote, "There are statements in the joint judgment, impliedly at least, that are disparaging not only of the expression, the federal balance, but also of the very concept of it. In my respectful opinion, they fail to pay due regard to our predecessors on this court who never doubted the importance of that concept." His Honour could see and express the obvious need to resist the tendency to centralise in a manner that I'd suggest got lost in the weeds of the majority's work. His Honour found there's nothing in the text or structure of the Constitution to suggest that the Commonwealth's powers should be enlarged, so that the Parliament of each state is progressively reduced until it becomes no more than an impotent debating society. And finally, at paragraph 797, he said that the federal balance is not to be maintained as a matter of political or social preference, but as a matter of constitutional imperative. In the years that have passed since this decision was delivered, its impact has been profound. It does, as Justice Callinan foreshadowed, undermine the federal balance and hollow out the states substantially. I don't think it could be said that centralisation or the promise of harmonisation in industrial relations or across a range of other spheres has served Australians particularly well, especially given that it came at the price of the benefits of competitive federalism. And it remains one of the most spirited defences of the proper role of the judge, of the essential character of the Federation, and of the primacy of Australians as the ultimate owners of the Constitution, whose good sense is never to be ignored. It cannot have been easy as a person appointed who had rather uncomfortably been described by politicians of the day as a capital C Conservative to defend his principles when a government of the colour that appointed him had wandered from them. But again, the passage of time has proven that that was a lesson the political class needed to learn. The Coalition paid a heavy price for the work choices legislation. If they'd had the wisdom of Justice Callinan, they would never have gone there. To conclude, during the time I had the pleasure of working for His Honour, a very long time ago now, I was perhaps unsurprisingly in awe of the role of the High Court and of the impact that a justice of that institution makes on the law and politics of the nation. Like so many young people, I hope to someday, in some small way, make an effort of my own to leave a mark of improvement. But with his usual humility, the judge always downplayed the significance of his contribution. He would say words to the effect of, The work we do here doesn't last more than a few years. It doesn't take long for the combination of legislation and subsequent cases to render most of what we do here obsolete. I've spent a lot of this paper saying that I think the judge has, even when in minority, been right. But on this final point, I am convinced he is wrong. For the wisdom of his work has certainly persisted. It has ripened and improved, I would suggest, with age, arguably becoming even more persuasive over almost 2 decades. And yet, that very humility also serves as a model for us, no matter the walk of life in which we seek to serve. Thank you.